Chief Justice and Senators, thank you for that question. We believe that the President's team has claimed basically there were 6 facts that have not been met and will not change, and all 6 of those so-called facts are incorrect.
Joe Biden says, let's remember one thing when it comes to impeachment. Donald Trump is on trial because he's afraid to run against me. He knows I'll beat him at this November. What?
I know, is that too funny? I have to respond to that.
Evidence of information before the meetings.
Well, he didn't impeach himself. What a fucking nut job.
To Mr. Zelensky's.
He's losing it, really.
That doesn't even make any fucking sense.
All of this evidence that makes us understand that phone call even more clearly.
Yeah, I'm waiting for him to drop out, like, quickly.
The President's team claimed that Mr. Zelensky and other Ukrainians said they never felt pressure to open investigations. Now, of course, they didn't say that publicly. They were afraid of the Russians finding out. But Zelensky said privately that he didn't want to be involved in U.S. domestic politics. He resisted announcing the investigations. He only relented and scheduled the
wow,
CNN
I just started.
after
Jeez.
it became clear that he was not going to receive the support that he needed and that Congress had provided in our appropriations. That's the definition.
I think I'll go with bitch over hag, man.
Lawyers say didn't know that Trump
Did he call you a hag?
security assistance
He's trying to. He's not successful at it, but he is trying.
Tested that, including the open statement by Olena Zirkle, who was then the deputy foreign
You know I
minister
would
of
never
Ukraine,
call you either one
that
of them.
they knew about the president's
Yeah, I know.
security matters.
Not to
And in
my
the end,
face,
everybody
anyway.
was public,
I'm gonna call you a
and, after
hooker.
was Ukraine did
I can
relent and
handle
scheduled
that one.
testimony. Fourth, they said no witnesses, said security was
Really,
sufficient.
I can handle them all.
Investigations
But,
not
you know,
so.
hooker's cool.
Mulvaney, we have other witnesses talking about the
Snap
shakedown of
Zoe.
the security assistance.
You don't have to
But
My
the
face,
other
anyway.
is
I'm
stupid
gonna
that
call you a
Dave
hooker.
Evans was to talk to the president.
I can
Boris
handle
Johnson
that
joined the
one.
Congress.
The president thought he was doing. They said no witnesses. Ultimately, of course.
Really, I can handle them
No,
all.
but it's
But,
still
you
talking.
know, hooker's cool.
Yeah, she's talking
They
about fucking nuts.
that the president promised.
Now that's a hag.
Has not occurred.
I called her a broad.
My face, anyway.
Wearing a pearl necklace is gross.
Dude,
Getting caught.
Boris Johnson joined the Congress.
Congress.
And what about Mary Earrings?
Ultimately,
Really, I can handle them all. But, you know, hooker's cool.
Yeah, she's talking about fucking nuts.
Now that's a hag.
I called her a broad.
My face, anyway.
Wearing a pearl necklace is gross.
There,
Boris Johnson joined the Congress. And what about Mary Earrings?
really, I can handle them all. But, you know, hooker's cool.
Yeah, she's talking about fucking nuts.
Yeah, it's a matching ensemble.
Now that's a hag.
I called her a broad.
My face, anyway.
Wearing a pearl necklace is gross.
There.
Boris Johnson joined the Congress. And what about Mary Earrings?
To be pursuing
Really, I can handle them all. But, you know, hooker's cool.
Yeah, she's talking about fucking nuts.
Yeah, it's a matching ensemble.
Now that's a hag.
I called her a broad.
My face, anyway.
Wearing a pearl necklace is gross.
Mr. Chief Justice,
Boris Johnson joined the Congress.
I send a question
What
to the
about
desk
Mary Earings?
for the President's Council on behalf of myself and Senators Bozeman, McSally, Blackburn, Kennedy, and Toomey.
interesting.
That's a parody account, right?
What, Joe Biden?
Yeah.
I called her a broad.
It
is?
No, no,
I tweeted it.
No, I'm being sarcastic.
I checked it. I just checked it again. It's got a blue check mark. I'm pretty sure that's supposed to be his.
McSally, Blackburn, Kennedy, and to me.
Interesting.
Yeah, you get it now.
Yeah. It should be a parody
Chief
account.
Justice, Senators, no, the House did not seek to litigate any of the privilege issues.
I mean, you expect
during
people
that
to take you
time.
seriously with that kind of
In
shit
fact,
coming out there? Come on.
They filed no lawsuits.
I take Joe in the death pool. I
arising
think he's going to be the
from
next one to
this
cross the bucket.
impeachment inquiry to seek to contest the bases that the Trump
Ah,
administration gave for resisting the
I
subpoenas,
went in
the
on that
basis
one.
for why those subpoenas were invalid. And when litigation was filed by one of the subpoena recipients,
Who?
that was Dr. Charles Kupperman, the Deputy National Security Advisor, he went to the court and sought a declaratory judgment saying, "The president's
thinks
told me
that
I
somebody's
shouldn't
gonna-
go. I have a subpoena from the
That-
House saying I should
Biden,
go.
Biden.
Please, court,
Kick
tell
the
me what are
bucket.
my obligations." And that was filed, I believe, around October.
He's gonna drop
25th,
dead of
end October.
something or,
Very shortly,
yeah,
within a few
or
days, the court has
maybe
already
escorted.
scheduled.
Yeah, I mean,
scheduled
he should
for
just
December
stop
10th.
already.
That was supposed to hear both
Wait, what about
preliminary
Bernie?
motions to
Well, Bernie,
dismiss,
he's only
but also
50.
the merits issues. So they were
What?
going to get a decision after hearing
Shut
this
up,
December 10th that
Trav.
would go to the merits of the issue. The House
But he's
That
looked
is
like,
boring.
he's looked like that since he was like 35,
Decided
36.
they wanted to moot out the case so they wouldn't get a decision. So no, the House has not pursued litigation to get any of these issues resolved. It's affirmatively avoided getting any litigation. And that seems to be, at least in part,
Old communists never die, they just moved to
if you
Argentina.
look at the House Judiciary Committee report, their
Stay
assertion
angry.
that under the sole power of impeachment assigned to the House believes that the Constitution assigns, I believe the exact words are, it gives the House the last word, something to that effect. And I mentioned this the other day. This is the new constitutional theory that because they have the sole power of impeachment, in their view, it's actually the paramount power of impeachment. And all other constitutionally based privileges or rights or immunities or roles even of the other branches, both the judiciary and the executive, fall away. And there is nothing that can stand in the way of the House's power of impeachment. If they issue a subpoena, the executive has to respond. And it can't raise any constitutionally based separation of powers concerns. If you do, that's obstruction. The courts have no role. The House has the sole power of impeachment. And that's a very dangerous construct for our Constitution. It suggests that once they flip the switch onto impeachment, there's no check on
Is that that Regis's
what they want to do.
nephew or cousin or
That's not
something?
the
Or
way
what?
the Constitution is structured. The Constitution
Philbin?
requires when there are interbranch
It's not a very common
there
name.
be an accommodation process, that there be attempts to address the interests of both branches. And the House has taken a position, and in other litigation.
Well, I don't want to be related to him.
The courts are the only way to resolve these issues.
So, Lisa,
And
did
they
you feel
brought
that earthquake?
case,
No,
in
did you?
August. They already have a decision.
Well,
from
come
the
on.
Supreme Court.
If
They
you
have a
didn't,
decision
I
from the
wouldn't.
Circuit. It
You're
was already
bigger
in
person than I am.
Yeah, that's true.
That's pretty fast for litigation, but they've decided in this impeachment
did not
they don't want to do litigation.
But I wondered if it
Again,
was
it's
the
because
natural.
They had a timetable.
Isn't that right by
Charges
Gitmo?
admitted on this floor, they had to get the president impeached before the election. They had no time for the courts. For
Miami?
anyone telling them what
Cuba?
the rules were.
Cuba, yeah.
And they had to get it done by Christmas, and that's what they did. And then they waited around for the month before bringing it here. And I think that shows you what's really behind the claims of, oh, it's urgent, then it's not urgent. It's urgent when it's our timetable to get done by Christmas. It's not so urgent when we can wait for a month because we want to tell the Senate how to run things. It's all a political charade. And that's part of the reason, a major reason, that the Senate should reject these articles of impeachment. Thank you.
Thank you, counsel.
Justice,
The senator from New Mexico.
thank you for the recognition, Mr. Chief Justice. I send a question to the desk.
The question is for the House managers. Please address the President's counsel's argument that House managers seek to overturn the results of the 2016 election and that the decision to remove the President should be left to the voters in November.
Thank you for the question. First I just want to respond to something Counsel just said. 9 months is pretty fast for litigation in the courts. Sadly, I agree with that. 9 months is pretty fast in the McGahn case, and we still don't have a decision yet. And what's more, that's the very case in which they're arguing, as I quoted earlier, that Congress has no right to come to the courts to force a witness to testify. So here we are 9 months later in that litigation that they said we're compelled under the Constitution to bring, and they're saying in court, you can't bring this, and it's 9 months and we still don't have a decision. I think that tells you just where they're coming from. It all goes back to the President's directive, fight all subpoenas, and they are. Nixon was going to be impeached for far less obstruction than anything that Donald Trump did. Now, the argument, well, if you impeach a president, you are overturning the results of the last election and you're tearing up the ballots in the next election. Okay, if that were the case, there would be no impeachment clause in the Constitution. Because by definition, if you're impeaching a president, that president is in office, has won an election. Clearly, that's not what the founders had in mind. What they had in mind is if the president commits high crimes and misdemeanors, you must remove him from office. It is not voiding the last election, it is protecting the next election. Indeed, the impeachment power was put in the Constitution not as a punishment, that's what the criminal laws are for, but to protect the country. Now, if you say you can't impeach a president before the next election, what you're really saying is you can only impeach a president in their second term. Okay, if that were going to be the constitutional requirement, the founders would have put in the Constitution, a president may commit whatever high crimes and misdemeanors that he wants as long as it's in the first term. That is clearly not what any rational framer would have written, and indeed they didn't. And they didn't for a reason. The founders were concerned that, in fact, the object of a president's corrupt scheme might be to cheat in the very form of accountability that they had prescribed, the election. So, counsel has continued to mischaracterize what the managers have said. We're not saying that we had to hurry to impeach the president before the election. We had to hurry because the president was trying to cheat in that election. And the position of the President's counsel is, well, yes, it's true that if a president is going to try to cheat an election, by definition, that's prior to their re-election. By definition, that's going to be proximate to an election. But, you know, let the voters decide, even though the object is to corrupt that vote of the people. That cannot be what the founders had in mind. One of the things I said at the very open of this proceeding is, yes, we're to look to history. Yes, we're to try to divine the intent of the framers, but we are not to leave our common sense at the door. The issue isn't whether this is his first term or his second. It isn't whether the election is a year away or 3 years away. The issue is, did he commit a high crime and misdemeanor? Is it a high crime and misdemeanor for a president of the United States to withhold hundreds of millions of dollars in aid to an ally at war to get help, illicit foreign interference in our election? If you believe that it is, it doesn't matter what term it is. It doesn't matter how far away the election is, because that president represents a threat to the integrity of our elections, and more than that, a threat to our national security. As we have shown by withholding that aid, and I know the argument, no harm, no foul, we held aid from an ally at war. We sent a message to the Russians when they learned of this hold that we did not have Ukraine's back. We sent a message to the Russians as Zelensky negotiations with Putin to try to end that war, that Zelensky was operating from a position of weakness because there was a division between the President of the United States and Ukraine. That's immediate damage. That's damage done every day. That damage continues to this day. The damage the President does in pushing out the Russian conspiracy theories, or identified during the House proceedings, and you've heard in the Senate, as Russian intelligence propaganda. The danger the president poses by taking Vladimir Putin's side over his own intelligence agencies, that's a danger today. That's a danger that continues every day he pushes out this Russian propaganda. The framers, if they meant impeachment only to imply in a second term, would have said so, but that would have made the Constitution a suicide pact. That's not what it says, and that's not how you should interpret it. By taking Vladimir Putin's side over his own intelligence agencies.
The senator from Ohio.
Yes.
Thank you. The question is directed to counsel for the president. Given that impeachment proceedings are privileged in the Senate and largely prevent other work from taking place while they are ongoing, please address the implications of allowing the House to present an incomplete case to the Senate and request the Senate to seek testimony from additional witnesses.
Thank you, Mr. Chief Justice, Senators. I think this is one of the most important issues that this body faces, given these calls to have witnesses, because the House managers try to present it as if it's just a simple question, how can you have a trial without witnesses? But in real litigation, no one goes to trial without doing discovery. No one goes to trial without having heard from the witnesses first. You don't show up at trial and then start trying to call witnesses for the first time. And the implications here in our constitutional structure for trying to run things in such an upside-down way would be very grave for this body as an institution. Because, as the senator's question points out, it largely prevents this chamber from getting other business done as long as there is a trial pending. And the idea that the House can do an incomplete job in trying to find out what witnesses there are, having them come testify, trying to find out the facts, just rush something through and bring it here as an impeachment, and then start trying to call all the witnesses, means that this body will end up taking over that investigatory task. And all of the regular business of this body will be slowed down, hindered, or prevented while that goes on. And it's not a question of just one witness. It's not a question of, a lot of people talk right now about John Bolton, but the president would have the opportunity to call his witnesses just as a matter of fundamental fairness. And there would be a long list of witnesses if the body were to go in that direction. That would mean this would drag on for months and prevent this chamber from getting its business done. There's a proper way to do things and an upside-down way of doing things. And to have the House not go through a process that is thorough and complete, and to just rush things through in a partisan and political matter and then dump it onto this chamber to clean everything up, is a very dangerous precedent to be set. As I said the other day, whatever is accepted in this case becomes the new normal. If this chamber puts its imprimatur on this process, then that's the seal of approval for all time in the future. And if it becomes that easy for the House of Representatives to impeach a president of the United States, don't attempt to subpoena the witnesses, never mind litigation, it takes too long, but then leave it all to this chamber. And as I said the other day, remember, what do we think will happen if some of these witnesses are subpoenaed now that they never bothered to litigate about? Then there'll be the litigation now, most likely, and then that will take time while this chamber is still stuck sitting as a court of impeachment. That's not the way to do things. And it would forever change the relationship between the House of Representatives and the Senate in terms of the way impeachments operate. So I think it's vitally important for this chamber to consider what it really means to start having this chamber do all that investigatory work, how this chamber would be paralyzed by that, and is that really the precedent? Is that the way this chamber wants everything to operate in the future? Once you make it that much easier, and we've said this on a couple of different points, both in terms of the standards for impeachable offenses, but also in terms of the process that's used in the House. You make it really way too easy to impeach a president, then this chamber is going to be dealing with that all the time. And as Minority Leader Schumer had pointed out, at the time of the Clinton impeachment, he was prophetic. As the White House counsel pointed out the other day, once you start down the path of partisan impeachments, they'll be coming again and again and again. And if you make it easier, they'll come even more frequently. And this chamber is going to have to spending a lot of time dealing with impeachment trials and cleaning up incomplete, half-baked procedures, rushed partisan impeachments from the House, if that's the sort of system that's given your imprimatur here. And that's a very important reason for not accepting that procedure and not trying to open things up now when things haven't been done properly in the House of Representatives. Thank you.
So, the senator from Delaware.
Mr. Chief Justice, I send a question to the desk.
The question is for the House managers. Some have claimed that subpoenaing witnesses or documents would unnecessarily prolong this trial. Isn't it true that depositions of the 3 witnesses in the Clinton trial were completed in only 1 day each? And isn't it true that the Chief Justice, as presiding officer in this trial, has the authority to resolve any claims of privilege or other witness issues without any delay?
Mr. Chief Justice, the answer is yes. What is clear, based on the record that was compiled by the House of Representatives, where up to 5 depositions per week were completed, that this can be done in an expeditious fashion. It's important to note that the record that exists before you right now contains strong and uncontroverted evidence that President Trump pressured a foreign government to target an American citizen for political and personal gain as part of a scheme to cheat in the 2020 election and solicit foreign interference. That is evidence from witnesses who came forward from the Trump administration, including individuals like Ambassador Bill Taylor, West Point graduate, Vietnam War hero, including individuals like Ambassador Sondland, who gave $1 million to President Trump's inauguration, respected national security professionals like Lieutenant Colonel Alexander Vindman, as well as Dr. Fiona Hill. 17 different witnesses, Trump administration employees, troubled by the corrupt conduct that took place as alleged and proven by the House of Representatives. But to the extent that there are ambiguities in your mind, this is a trial. A trial involves witnesses. A trial involves documents. A trial involves evidence. That is not a new phenomenon for this distinguished body. The Senate in its history has had 15 different impeachment trials. In every single trial, there were witnesses. Every single trial. Why should this president be treated differently, held to a lower standard at this moment of presidential accountability? And in fact, in many of those trials, there were witnesses who testified in the Senate who had not testified in the House. That was the case, most recently, in the Bill Clinton trial. It certainly was the case in the trial of President Johnson. 37 out of the 40 witnesses who testified in the Senate were new. 37 out of 40. Why can't we do it in this instance? When you have such highly relevant witnesses like John Bolton, who had a direct conversation with President Trump, indicating that President Trump was withholding the aid because he wanted the phony investigations. Counsel has said the greatest invention in the history of jurisprudence for ascertaining the truth has been the vehicle of cross-examination. Let's call John Bolton. Let's call Mick Mulvaney. Let's call other witnesses, subject them to cross-examination, and present the truth to the American people.
Mr. Chief Justice.
The senator from Texas.
Mr. Chief Justice, I have to send a question to the desk.
Thank you. Senator Cornyn asks counsel for the president, what are the consequences to the presidency, the president's constitutional role as the head of the executive branch, and the advice the president can expect from his senior advisors if the Senate seeks to resolve claims of executive privilege for subpoenas in this impeachment trial without any determination by an Article III court?
Mr. Chief Justice, thank you, Senator, for the question. The Supreme Court has recognized that the confidentiality of communications with the President is essential. Keeping those communications confidential is essential for the proper functioning of government. In Nixon versus the United States, the Court explained that this privilege is grounded in the separation of powers and essential for the functioning of the executive for this reason. In order to receive candid advice, the President has to be able to be sure that those who are speaking with him have the confidence that what they say is not going to be revealed, that their advice can remain confidential. If it's not confidential, they would temper what they're saying. They wouldn't be candid with the President. And they wouldn't be able, the President then would not be able to get the best advice. And it's the same concern that underpins the deliberative process aspect of executive privilege. Even if it's not a communication directly with the President, if it's the deliberative process within the executive branch, people have to be able, before coming up with a decision, to discuss alternatives, to probe what other ways might work to address a problem, and to discuss them candidly and openly, not with the feeling that the first thing they say is going to be on the front page of the Washington Post the next day. Because if you don't have the confidence that what you're saying is going to be kept confidential, you won't be candid, you won't give your best advice. And that damages decision-making. That's bad for the government, and it's bad for the people of the United States, because it means the government and the executive branch can't function efficiently. So there is a critical need for the executive to be able to have these privileges and to protect them. And that's why the Supreme Court recognized that in Nixon versus United States and pointed out that there has to be some very high showing of need from another branch of government if there's going to be any breach of that privilege. And that's why there is an accommodations process. While the courts have said that when the Congress, when the legislature seeks information from the executive, and the executive has confidentiality interests, both branches are under an obligation to try to come to some accommodation to address the interests of both branches. But it's not a situation of simply the Congress is supreme and can demand information from the executive, and the executive must present everything. And the courts have made that clear, because that would be damaging to the functioning of government. And so here in this case, there are vital interests at stake. And, you know, in one of the potential witnesses that the House managers have raised again and again is John Bolton. Well, John Bolton was the national security advisor to the president. He has all of the nation's secrets from the time that he was the national security advisor, and that's precisely the area, the field, in which the Supreme Court suggested in Nixon versus United States there might be something approaching an absolute privilege of confidentiality in communications with the president, the field of national security and foreign affairs. That's the crown jewels of executive privilege. And so to suggest that the national security advisor, well, we'll just subpoena him, he'll come in, and that'll be easy, there won't be any problem, that's not the way it would work, because there's a vital constitutional privilege at stake there. And it's important for the institution of the office of the presidency, for every president to protect that privilege. Because once precedents start to be set, if one president says, well, I won't insist on the privilege then, I'll let people interview this person, I won't insist on the immunity, that sets precedents. And then the next time, when it's important to preserve the privilege, the precedent is raised, and the privilege has been weakened, and it's forever weakened, and that damages the functioning of government. So this is a very serious issue to consider. It's important, the Supreme Court has made clear, for the proper functioning of the executive branch, for the proper functioning of our government, and there would be grave issues raised attempting to have a national security advisor to the president come under subpoena to testify. And that would all have to be dealt with, and that would take some time before things would continue. Thank you.
Counsel? The senator from Hawaii.
Mr. Chief Justice, I send a question to the desk.
The question from Senator Schatz is directed to the House managers. And also from Senator Feinstein. If the president were acting in the interest of national security, as he alleges, would there be documentary evidence or testimony to substantiate his claim? If yes, has any evidence like that been presented by the president's counsel?
Thank you, Mr. Chief Justice. Thank you, Senators, for the question. The answer is yes. Right? There are well-established processes, mechanisms, and agencies in place to pursue valid and legitimate national security interests of the United States, like the National Security Council, like the National Security Advisor, as in Ambassador John Bolton, and many other folks within the State Department and the Department of Defense. And as we have well established over the last week, none of those folks, none of those agencies that would have been involved in having that deliberation, reviewing that evidence, having that discussion, were incorporated into any type of interagency review process during the vast majority of the time that we are talking about here. From the time of the president's call on July 25th to the time the hold was lifted, those individuals, those agencies were in the dark. They didn't know what was happening. And more so, not only were they in the dark, but the president violated the law by violating the Impoundment Control Act to execute his scheme. None of that suggests a valid, legitimate policy objective. More so, the president himself and his counsel is bringing at issue the question of documents and witnesses. If over and over again, as we've heard in the last few days, that the president was simply pursuing a valid, legitimate policy objective, if this was a specific debate about policy, a debate about corruption, a debate about burden sharing, then let's have the documents that would show that. Let's hear from the witnesses that would show that, because the documents and the witnesses that we have forwarded, that we have talked about, show the exact opposite. So the American people in this chamber deserve to have a fair trial. The president deserves to have a fair trial. In fact, if he is arguing that there is evidence that there was a policy debate, then I think everybody would love to see those documents, would love to see the witnesses, hear from them directly about what exactly was being debated.
Thank you, Mr. Manager.
Mr. Chief Justice,
The senator from South Carolina.
I sent a question to the desk for myself and Senator Cruz.
Thank you. Senator Graham and Senator Cruz pose this question for the House managers. In Mr. Schiff's hypothetical, if President Obama had evidence that Mitt Romney's son was being paid $1 million per year by a corrupt Russian company and Mitt Romney had acted to benefit that company, would Obama have authority to ask that that potential corruption be investigated?
Well, first of all, the hypothetical is a bit off because it presumes that in that hypothetical that President Obama was acting corruptly, or there was evidence he was acting corruptly with respect to his son. But nonetheless, let's take your hypothetical on its terms. Would it have been impeachable if Barack Obama had tried to get Medvedev to do an investigation of Mitt Romney, whether it was justified or unjustified? The reality is, for a president to withhold military aid from an ally, or in the hypothetical, to withhold it to benefit an adversary, to target their political opponent is wrong and corrupt, period. End of story. And if you allow a president to rationalize that conduct, rationalize jeopardizing the nation's security, to benefit himself because he believes that his opponent should be investigated by a foreign power, that is impeachable. Now, if you have a legitimate reason to think that any U.S. person has committed an offense, there are legitimate ways to have an investigation conducted. There are legitimate ways to have the Justice Department conduct an investigation. Now, I would suggest to you that for a president to turn to his Justice Department and say, I want you to investigate my political rival, taints whatever investigation they do. Presidents should not be in the business of asking even their own Justice Department to investigate their rivals. The Justice Department ought to have some independence from the political desires of the president. And one of the deeply troubling circumstances of the current presidency is you do have a president of the United States speaking quite openly, urging his Justice Department to investigate his perceived enemies. That should not take place either. But under no circumstances do you go outside of your own legitimate law enforcement process to ask a foreign power to investigate your rival, whether you think there's cause or you don't think there's cause. And you certainly don't invite that foreign power to try to influence an election to your benefit. It's remarkable to me that we even have to have this conversation. I mean, our own FBI director has made it abundantly clear, and it shouldn't require an FBI director to say this, that if we were approached with an offer of foreign help, we should turn it down. We should, of course, certainly not solicit a foreign country to intervene in our election. And whether we think there's grounds or we don't, the idea that we would hold our own country's security hostage by withholding aid to a nation at war to either damage our ally or help our adversary because they will conduct an investigation into our opponent, I can't imagine any circumstance where that's justified. And I can't imagine any circumstance where we would want to say the President of the United States can target his rival, can solicit illicit foreign help in an election, can help him cheat, and that's okay. Because that will dramatically lower the bar for what we have a right to expect in the President of the United States, and that is they're acting in our interests. So I would say it's wrong for President of the United States to be asking for political prosecutions by his own Justice Department. I would say it's wrong for President of the United States to ask a foreign power to engage in an investigation of his political rival, but particularly where, as we have shown here, there is no merit to that investigation is even more egregious. And you know there's no merit to it because he didn't even want the investigation. And the more accurate parallel, Senator, would be if Barack Obama said, I don't even need you, Russia, to do the investigation. I just want you to announce it. Because that betrays the fact there was no legitimate basis, because the president didn't even need the investigation done. He just wanted it announced. And there is no legitimate explanation for that except he wanted their help in cheating in the next election.
Thank you, Mr. Manager. The senator from Michigan.
Mr. Chief Justice, I send a question to the desk.
Thank you. The question from Senator Peters is for the House managers. Does the phrase "or other high crimes and misdemeanors" in Article 2, Section 4 of the Constitution require a violation of the U.S. Criminal Code, or is a breach of public trust sufficient? Please explain.
Framers were very clear that abuse of power is an impeachable offense. In explaining why the Constitution must allow impeachment, Edmund Randolph warned that, quote, the executive will have great opportunities of abusing his power. Alexander Hamilton described high crimes and misdemeanors as offenses which proceed from the abuse or violation of some public trust. The framers also described what it meant. It was impeachable for a president to abuse his pardon power to shelter people he was connected with in a suspicious manner. Future Supreme Court Justice James Iredell said the president would be liable to impeachment if he'd acted from some corrupt motive or other, or if he was willfully abusing his trust. As was later stated in a treatise summarizing centuries of common law, abuse of power occurs if a public officer entrusted with definite powers to be exercised for the benefit of the community wickedly abuses or fraudulently exceeds them. So when the framers said this, that abuse of power was impeachable, it wasn't just an empty, meaningless state. Remember, the founders had been participating with overthrowing the British government, a king who was not accountable. They incorporated the impeachment power into the Constitution late, actually, in the drafting of the Constitution. They knew that they were giving the president many powers, and they specified if he abused them, that those powers could be taken away. Now, the prior articles that the Congress has had on impeachment did not include specific crimes. President Nixon was charged with abusing his power, targeting political opponents, engaging in a cover-up. Now, there was conduct specified. Some of it was clearly criminal, some of it was not. But it was all impeachable because it was corrupt and it was abusing his power. In the House Judiciary Committee, we had witnesses called by both Republicans and Democrats, and the Republican-invited constitutional law expert, Jonathan Turley, testified unequivocally that it is possible to establish a case for impeachment based on a non-criminal allegation of abuse of power. Every presidential impeachment, including this one, has included conduct that violated the law, but each presidential impeachment has included the charges directly under the Constitution. It's important to note that a specific criminal law violation was not in the minds of the founders, and it wouldn't make any sense today. You could have a criminal law violation, you could deface a post office box. That would be a violation of federal law. We would laugh at the idea that that would be a basis for impeachment. That is not abuse of presidential powers. It might be a crime. And yet you could have activities that are so dangerous to our Constitution that are not a crime that would be charged as an impeachable offense because they are an abuse of power. That's what the framers worried about. That's why they put the impeachment clause in the Constitution. And frankly, they opined that because of the impeachment clause, no executive would dare exceed their powers. Regrettably, that prediction did not prove true, which is why we are here today with President Trump having abused his broad powers to the detriment of our national interest for a corrupt purpose, his own personal interests. Thank you.
Thank you, counsel.
Mr. Chief Justice.
Oh, Senator, thank you.
Thank you, Mr. Chief Justice. I send a question to the desk on behalf of myself and Senator Murkowski.
Thank you, Senator. Senators ask counsel for the President. Describe in further detail your contention that all subpoenas issued prior to the passage of House Resolution 660 are an exercise of invalid subpoena authority by the House committees.
Mr. Chief Justice, thank you, senators, for that question. As I explained the other day, this contention is based on a principle that has been laid out in several Supreme Court cases, explaining that the Constitution assigns powers to each house of the legislative branch, to the House of Representatives or to the Senate. And in particular, the language of the Constitution is clear in Article 1 that the sole power of impeachment is assigned to the House. That's to the House of Representatives as a body. It's not assigned to any committee, to a subcommittee, or to any particular member of the House. And in cases such as Roomley versus United States and the United States versus Watkins, the court has been called, there are disputes about subpoenas. They're not specifically in the impeachment context, but they establish a general rule, a principle, that whenever a committee of either body of Congress issues a subpoena to someone and that person resists the subpoena, the courts will examine what was the authority of that committee or subcommittee to issue that subpoena. And it has to be traced back to some authorizing rule or resolution from the House of Representatives itself, for example, in a House subcommittee. And the courts will examine, the Supreme Court has made clear that that is the charter of the committee's authority. It gets its authority solely from an action by the House itself. That requires a vote of the House, either to establish the committee by resolution or to establish by rule the standing authority of that committee solely from an action by the House itself. If the committee cannot trace its authority either to a rule or a resolution or to establish by then its subpoena is invalid, and the Supreme Court's made clear in those cases such subpoenas are null and void because they're ultra vires. They are beyond the power of the committee to issue. They can't be enforced. And our point here is very simple. The Supreme Court's made clear there is no standing rule in the House are null and void that provides the committees that were issuing subpoenas here. And our point here is the leadership of Manager Schiff, the authority to use the impeachment power to issue subpoenas. Rule 10 of the House defines the legislative jurisdiction of committees. It doesn't mention the word impeachment even once. And so no committee under Rule 10 was given the authority to issue subpoenas for impeachment purposes. And this has always been the case in every presidential impeachment in the history of the nation, power of impeachment, before it attempted to issue compulsory process. So in this case, there was no resolution from the House. The authority, the sole power of impeachment, remained with the House of Representatives itself, and Speaker Pelosi, by herself, did not have authority merely by talking to a group of reporters on September 24th to give the powers of the House to any particular committee to start issuing subpoenas. So the subpoenas that were issued were invalid when they were issued. And then 5 weeks later, on October 31st, when the House finally adopted House Resolution 660 that authorized from that point, purported to authorize at least from that point, the issuance of subpoenas, nothing in that resolution addressed the subpoenas that had already been issued. It didn't even attempt, it didn't purport to say the ones that have already been issued, we're going to try to retroactively give authority for that. It's a separate question whether that could have been done legally. They didn't even attempt to do it. And this is all explained in the opinion from the Office of Legal Counsel, which is in our trial memorandum attached as Appendix C. And it's a very detailed and thorough opinion, 37 pages of legal reasoning, but it explains all of this. The basic principle that applies generally, the history that it has always been done this way. There has always, in every presidential impeachment, been an authorizing resolution from the House, and the fact that there was none here. So there was no authority for those subpoenas. And that means that 23 subpoenas that were issued were invalid. And this was explained, as I pointed out the other day, in letters from the administration to the committees, a letter from the White House, from OMB, I think the State Department, and in very specific terms, it set out this rationale. So that is the basis on which those subpoenas were invalid, and they were properly resisted by the administration.
The senator from Pennsylvania. The question is directed to the House manager. In 65, Alexander Hamilton writes that the subject of impeachment which proceed from the misconduct or, in other words, from the abuse or violation of some public trust. Could you speak broadly to these being public servant and how you believe the President's actions have violated this trust?
Mr. Chief Justice, members of the Senate, President Trump attempts to investigate his abuse of power. These actions are clear. The key purpose of the impeachment clause is to control abuses of power by public officials, that is to say, conduct that violates the public trust. Since the founding of the Republic, all impeachments have been based on accusations of conduct that violates the public trust. When the framers wrote the phrase high crimes and misdemeanors, they intended to capture the conduct of public officials like President Trump, who showed no respect for their oath of office. President Trump ignored the law and the Constitution in order to gain a political favor. The Constitution and his oath of office prohibited him from using his official favor to corruptly benefit himself rather than the American people. That's exactly what the President did, illegally withholding military aid and a White House meeting until the President of Ukraine committed to announcing an investigation of President Trump's opponent. In the words of one constitutional scholar, if what we're talking about is not impeachable, then nothing is impeachable. This is precisely the misconduct that the framers created the Constitution, including impeachment, to protect against. And now I want to add, in reference to some of the comments that were made by some of the President's counsel a few minutes ago. They talk about the subpoena power, about the failure of the House to act properly in the subpoena power, because they said the House did not delegate by rule, have a resolution authorizing the committees to offer subpoena power. They apparently haven't read the fact that the House has generally delegated all subpoena power to the committees. That wasn't true at the time of the Watkins case. It wasn't true 15 years ago, but it is true now. Second, the House has the sole power of impeachment, and the manner of its exercise may not be challenged from outside. Whether we do it, the President should be convicted upon our accusation is a question for the Senate. But how we reached our accusation is a matter solely for the House. Thirdly, they talk about executive privilege. And they point to the Nixon case that established executive privilege, that the President has a right to candid advice, and therefore executive privilege is established. But the same case says that executive privilege cannot be used to hide wrongdoing. And in fact, President Nixon was ordered in that case to turn over all the material. Thirdly, there's the doctrine of waiver. You cannot use executive privilege or any other privilege if you waive it. The moment President Trump said that John Bolton was not telling the truth when he said that the President told him of the improper quid pro quo, he waived any executive privilege that might have existed. He cannot characterize a conversation and put it into the public domain and then claim executive privilege against it. The President, by the way, never claimed executive privilege, ever. He has claimed instead absolute immunity, a ridiculous doctrine that the President has absolute immunity from any questioning by the Congress or by anybody else, a claim rejected by every court that has ever considered it. And finally, the difference from this President and any other President claiming privilege of any sort is that this President told us in advance, I will defy all subpoenas. Whatever their nature, I will make sure that the Congress gets no information. In other words, I am absolute. The Congress cannot question what I do because I will defy all subpoenas. I will make sure they get no information, no matter what their rights, no matter what the situation. That is the subject of Article 2 of the impeachment, because that is a claim of absolute monarchical power.
Thank you, Mr. Manager. The Majority Leader is recognized.
I'm going to suggest after two more questions on each side, one more, I've been corrected, as I frequently am. One more question on each side, we take a 15-minute break.
Thank you.
Mr. President.
Yes, the Senator from Kansas.
I sent a question to the desk for the Counsel for the President.